I want to echo not only what you just said with great precision, but also the remarks that have been made by the speakers before me. I would, in my time, thank the UN for raising a challenge to the rule of law hypocrisy that characterizes so much of the judicial rhetoric that we hear concerning the Mumia Abu-Jamal case. Often we hear judges talk about following the rule of law and following precedent. But as the dissenting judge mentioned, Mumia Jamal has been denied the opportunity to gain the benefit of court precedents. The most recent example, glaring, is the fact that 6 boxes of evidence were discovered, if you want to use that term, decades after Mumia Jamal was arrested, charged, prosecuted, tried, convicted, sentenced to death, appealed, spent decades on death row, had his death row sentence overturned, and even decades later, fighting for justice, this evidence had not been disclosed to the defense team. When in 1963, the United States Supreme Court in the case of Brady versus Maryland held that due process of law requires that prosecutors reveal any exculpatory evidence to defense counsel, and that the failure to do so, that concealment of exculpatory evidence, violates fundamental fairness, what we call due process. An earlier case cited in Brady, dated 1935, said that when you have that kind of concealment, you have a pretense of a trial. Now, in 2022, the importance of the UN Amicus brief is that it calls on the American justice system, and specifically Judge Lucretia Clemens, to answer the question whether or not she will say that Mumia Jamal had a pretense of a trial. A pretense of a trial when prosecutors were allowed to engage in flagrant abuses of Batson, as Dr. Hernandez has just now mentioned, but also a pretense of a trial to the extent that exculpatory evidence was knowingly concealed and kept from Jamal's defense team for decades. 2019 was when it was discovered. This is now 2022. And the question now is, 40 years after Jamal's trial and conviction, is whether or not Judge Lucretia Clemens will have the courage and the integrity to decide that Mumia Jamal is entitled, he has a right to benefit from the decisions that say that concealment of evidence, exculpatory evidence, violates fundamental fairness. If there is such a thing as due process of law, if the rule of law means anything, Judge Clemens should decide this case in one way. First, she should decide that Mumia Jamal was denied due process. Exculpatory evidence was concealed from him, from his defense counsel, so that he was not able to use it at trial on the issue of guilt or punishment. That's a violation of due process. Secondly, the remedy is clear. There is nothing that Mumia Jamal could have done to discover this evidence. This is not something that he could have, or his defense team could have remedied. And therefore, the only remedy for this is for him to be released from what is only an unjust conviction and an unjust sentence. The question is, why would that not happen? Why, if there is a almost 60-year history of court precedent since Brady versus Maryland in 1963, that says that concealing exculpatory evidence violates due process, and in Brady, a first-degree murder charge was overturned. In Mooney versus Holohan, a California case in 1935, a first-degree murder charge was overturned, conviction overturned. And so the question is, why not Mumia? Why not Mumia Abu-Jamal? The question might be answered this way. Perhaps our criminal, and I don't call it a criminal justice system. Let's stop using that term. It's a criminal punishment system. Its aim is not justice. Its aim is punishment. And, and the reason why Mumia Abu-Jamal is in prison now is because the system is geared toward punishing, not justice. And the people who are targets most and first for punishment are Black, brown, and radical liberating-minded people. Mumia Jamal can be set free if Judge Clemens is committed to justice and not to punishment. And if she is committed to following the precedent, giving Mumia the benefit of precedent that existed long before 1982 when he was tried. I cited you to a 1935 case from California, 50 years before Mumia was tried. And so the relief that he is entitled to is relief that the American system of courts have recognized as entitled for people whose due process rights have been violated. The question is whether or not Judge Lucretia Clemens has the courage and the institutional integrity to grant it. I will conclude on this notion. As a state court trial judge who has tried murder cases and presided over murder cases, I understand the pressures that weigh on judges to defer to public opinion and especially to police opinion. However, as someone from Arkansas, the case of Moore versus Dempsey, arising from the Elaine Race Massacre of 1919, a 1923 case from the US Supreme Court, speaks very loudly to me. In that case, 5 Black men were tried and convicted of murder in less than 30 minutes in a mob-dominated trial. And Supreme Court of the United States overturned that conviction and held they were entitled to a new trial based upon a habeas petition brought on their behalf. Mumia Abu-Jamal is entitled to the same kind of relief. The UN working group says so. The question is whether or not a judge in Philadelphia has the courage to say so. Mumia's freedom lies on that question. Thank you.